Hi, I'm Steve Carlson. I'm the Independence Party nominee for the United States Senate, running against Al Franken and Mike McFadden, but you'd never know it from listening to FCC licensees who sponsored so-called U.S. Senate candidate debates featuring only the DFL party, part of Barack Obama's party, and the Minnesota GOP, part of the Republican establishment party, because they have ensured that campaign debates, even on FCC licensees like WCCO CBS, Minnesota Public Radio, and My9 TV in Duluth, will never put their candidates at risk of losing a U.S. Senate seat. And in my case, Franken and McFadden, who are two peas in a pod, only one's funnier, have negotiated with Minnesota mainstream media a season-long general election policy of excluding the Independence Party nominee from their so-called Senate candidate debates. And it turns out that this fiasco grew out of the events surrounding the tragic death of Senator Paul Wellstone, who I worked with on several occasions decades ago. But let's go back to 1998. 6 weeks before the 1998 gubernatorial election in Minnesota, the Star Tribune pegged Reform Party candidate, and that's what the Independence Party is, the Reform Party, Jesse Ventura, at 10% in the polls. 3 debates later, on October 20th, he was at 21%. Remarkably, Ventura's cash-strapped campaign had not yet aired a single television advertisement. On Election Day, Ventura captured 37% of the vote and became the governor of Minnesota. Governor Ventura explained his astounding victory. Quote, "I was allowed to debate. I proved that you could go from 10% to 37% and win if you're allowed to debate. Rest assured, these two parties don't want to ever see that happen again," unquote. Truer words were never spoken. That was 1998, and it was in 2002, with the tragedy of Wellstone, that a Minnesota court began this exclusion, not even considering the major party status of the Independence Party. Now I'm reading from my motion for injunction in the U.S. Supreme Court that is pending, and I am asking them to lift the unconstitutional burden on the First Amendment rights of the free association and free expression of the Independence Party, which this Minnesota Supreme Court has imposed on that party and which is hitting me as the Independence Party nominee. CBS Broadcasting, owner of WCCO, appearing in the Minnesota Supreme Court against the Independence Party, brought to light that the problem of excluding Independence Party nominees from publicly broadcast debates actually began in 2002, when another Independence Party candidate for U.S. Senate, James Moore, got caught up in tragic circumstances involving the death, October 25, 2002, of the late Senator Paul Wellstone. And I cite them to that case, which is included and forwarded to the U.S. Supreme Court. That tragedy produced a, quote, new election landscape, unquote. NPR, the same broadcaster of the debate Sunday night, November 2nd, was the defendant in this case. The judge, Honorable Michael M. Monahan, found the fact that access to media is in the legally unfettered hands of private bodies has sobering implications for the vitality of a democratic system, unquote. Nevertheless, given, quote, the current state of the law as opposed to notions of fundamental fairness and organizational consistency of NPR, who had invited Moore to be on, he denied the motion. But this is a different related motion in the form of a temporary restraining order or preliminary injunction to include the 2014 Independence Party nominee for U.S. Senate in the 2014 U.S. Senate campaign debate season by enjoining my participation on Sunday night, November 2nd. The motion for injunction to enter the WCCO debate, Exhibit C, was denied by the court below, that's the Supreme Court of Minnesota, as moot after the case was thrown out. The Minnesota Supreme Court has failed in its duties under the United States Constitution to enforce the prescription of the Minnesota Legislature. That is to say, to exercise its jurisdiction and enforce the law and Constitution and make sure the election of U.S. Senators conducted fairly and with due regard to my rights and the IP's under the First Amendment and equal time requirements. The sobering implications noted by Judge Monahan were not just, well, they were not lost on NPR or the broadcast and other media or the campaigns here of Senator Al Franken and Mike McFadden. They have seized on this opportunity, relying on this decision by Judge Monahan, a state court district judge, to expand impermissibly a whole new election landscape for Minnesota, which is unrestrained by notions of accountability to the First Amendment, due process, the duty of the state to enforce its election laws in electing members of the U.S. Senate, or equal time requirements of the FCC. And I add, the due process implications of this unconstitutional election process is that the laws will be made and substantively and procedurally enforced without the constitutional basis of selection. This violates my due process rights to have my laws passed by my duly elected representatives, and this violation extends to the rights of all Americans. I will not repeat this in the motion. So in other words, I'm not going to argue due process in the motion except to state that. Now, as a result of this expansion of NPR's new landscape announced in more modest form in 2002 in the Moore case, in the 2014 campaign, what is being challenged here is the total exclusion of the Independence Party U.S. Senate nominee, movement Steve Carlson, elected in a statewide primary for the entire 2014 general election season. This includes the Duluth debate, October 1st, the WCCO-CBS debate, October 26th, and the upcoming NPR debate, November 2nd. And I use the term debate advisedly because it is not complete. It is a fraud. It's a sham. Just trying to present the two major, so-called major national parties, let's say, on the stage, and deliberately excluding our third major party, the Independence Party. And the petition in motion in the Minnesota court shows how this was consciously and blatantly planned and negotiated by these Democrat and Republican campaigns and 12 different sites involving multiple potential broadcast licensees. This is unprecedented. It is a free-for-all. And Senator Franken, as an FCC specialist and media professional, has managed an entirely new concept which will expand the tragic six-day election landscape of 2002 to the entire nation and seriously undermine the entire democratic system. It is movement's position that the Moore decision was not warranted by the law at that time or at this time, since a state, here the state of Minnesota, has the power and duty to regulate its elections according to its laws and the U.S. Constitution, with some regulation by Congress, and certainly should not be applied to justify this program of exclusion by the two parties and use of three different broadcast facilities. Further, NPR and the media generally have directly engaged in viewpoint discrimination against me because I am a Tea Party candidate for U.S. Senate, and because of some views, NPR specifically, both Mike Mulcahy, news director, and Tom Scheck, reporter, have very falsely and injuriously attributed to me. The issue is not whether the First Amendment protects their malicious comments, but whether when they claim an editorial right to exclude me from their broadcast debate, they are engaging in impermissible viewpoint discrimination as well as trespassing my First Amendment rights of political expression and political association. And my argument is grounded in the United States Constitution. And that Constitution's assignment of duties of sitting Minnesota Supreme Court judges to enforce elections of U.S. Senate through their omnibus election jurisdiction so that these broadcasts and the Democrats and Republicans will at last comply with the U.S. Constitution. This duty of the Minnesota Supreme Court grows out of Section 4 of Article 1 of the U.S. Constitution, which declares that, quote, The elections for senators and representatives shall be prescribed in each state by the legislature thereof, unquote. And as I say, I don't doubt that these elected judges and most lawyers are simply ignorant of this duty, and they need the guidance of the U.S. Supreme Court. And now is the time. The future of the independent voters and the Minnesota Independence Party is at stake. The time for change is now. I'm Steve Carlson, and I approve this message. I'll continue on a second video to be called Minnesota's Constitutional Duty to Hold Free and Fair Elections. It starts with the case Ex parte Yarborough about black voters who were physically intimidated so they would not try to vote in federal elections.